Hello, how are you? How you feeling? I am back as promised with another video on detention. Okay, I think the subject, we don't talk a lot about how to challenge unlawful detention, or how to just get out of detention if a person has been detained by ICE. So I want to talk about the subject because we have a couple people in detention centers, and we wanted to address those issues, and perhaps it can help somebody, or you might forward this message to somebody who can hire an attorney for release. Okay. Again, as you know it, my name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases. If you need a consultation, again, do not hesitate to schedule it by using the consultation link in the bio, in the description box. Okay. Well, detention. Why does detention happen? Couple reasons, right? Person has been ordered removed. Person entry without inspection. When a person enters the United States without inspection, the person will be detained. For criminal reasons, the person will be detained. Or for overstay visa, the person might get detained, and sometimes by mistake the person might get detained. We've seen it a lot under this current administrations, a lot of mistakes when it comes to detention, and that's why we want to see how you can challenge unlawful detention, or how you can challenge prolonged detention, being detained for too long, or how you can just get out of detention altogether. The first thing you have to know is we have to establish first under what provision of the law you've been detained by ICE. Under what provision? It could be 236 or it could be 241. Those are the two major provisions that a person can be detained under. When it comes to 236, we have 236A and we have 236C. 236A, that's really when you are eligible for a bond, okay? When a person is detained under 236A, that person is eligible for bond. The way it works is that there's a standard to request bond and custody redetermination. We have to find out whether a person is a danger to community or whether the person is a flight risk. Danger to community, that's crimes, if the person is involved in criminal activities. And those circumstances can always be mitigated depending on the conviction, the charges, the time served and stuff like that. That's when the lawyer come into play to really establish the case and assess the case properly. And flight risk is basically saying that the person is going to run away again. They're going to evade immigration laws. They're going to run away again. And you have to make sure to establish that the person is not a flight risk. Those circumstances could be like, can establish that the person never missed a court hearing. If the previous court hearing the person showed up, right? You can establish that. The person has family ties here in America, community ties, job, employment. There are several factors that can help you establish that the person is not a flight risk. And then you ask for a bond, depending on how much. Sometimes it's a lot, sometimes it's less. You can ask for redetermination to lower the amount. That's the job of the lawyer, of course. Then the person can be released on bond. And sometimes the person can be released under their own recognizance. Basically, ICE decided, you know what, this person is not a criminal, not a danger to society, not a flight risk. We're going to just release them under their own recognizance. And then maybe they're going to place them under order of supervision. Even those who are released on bond, they can be placed under order of supervision. And that's 236A type of bond you're asking for. But when it comes to the 236C, that's mandatory detention. That's where the crimes are very high. And sometimes you might ask for bond and might not get it. But it's just depending on how you can argue. And then we have people who are detained under 241. Those are the people generally, those are the people who already been ordered removed, and then the case is pending judicial review, meaning that their case is on a federal court level. Let's say the person applies for asylum, get denied by the immigration court. The person goes to BIA to file for an appeal. The appeal gets denied, or the appeal gets dismissed. Then the person goes to the federal court for judicial review. Those people, when they get detained, most of the time they are detained under 241. And when you're detained under 241, the general rule is that you're going to stay there for longer, right? You're going to stay there maybe for 90 days. And depending on what the judge will say, sometimes you really stay there long. That's how a person, get detained, and the possibility of releasing them. Sometimes you can ask the person, the ICE, really negotiate with ICE, ask for parole, humanitarian parole, to be released on humanitarian parole, to be released just by filing a request for release from custody. Request for release from custody, we've done that too, right? Sometimes it works under this current administration. Oh, good luck, but it's a procedure you can always try. And if the person gets released, the person is out. Now we're waiting for, either the person is waiting for an appeal, or the person is just under order of supervision, or maybe the person they have court hearing to attend. That's a victory when a person is released. But what happened when the person is detention has been prolonged, like for too long, then required by law, basically, or you just find that it's not necessary for that person to be detained, or unlawful detention? That's when you file a habeas corpus in federal court. It helps to for the judge to either release the person, and the judge to determine custody and stop the transfer if they're trying to transfer the person to the south, because right now they're really transferring people to the south because that is really good for them in terms of deportation, right? And forum shopping, basically they finding jurisdiction where it's favorable in terms of deportation. So if a person gets detained, you have to make sure that you stop the transfer. That's when habeas corpus come into play. And from the other news we heard, I talked about it in my, not the latest one, but I guess maybe 2 weeks ago, the Trump administration was trying to stop, limit habeas corpus type of filing in federal court. But that's really a right that the non-citizens have to challenge their unlawful detention, or to challenge the detention, basically. I don't know how they're going to stop it, but it's in the process. If I hear more about it, I'll talk about it. But anyway, those are the things that you do in terms of releasing a person from detention. But how can you just avoid detention altogether? Well, you can avoid detention altogether by really not trying to commit crimes, basically, and trying to have a competent lawyer to file an appeal on time, because appeal stays removal order, and try to really have somebody who understands all the principles and all the complexity of this immigration system and the immigration laws, so that they can help you out to avoid detention. But sometimes detention is just mandatory in terms of crimes, in terms of entry, the way you're entering. But again, if you need consultation, or you know somebody who's in detention and you want to do consultation on their behalf, because the person's detention probably cannot do it, you have to have somebody outside who's going to do it on. Then you can, don't forget to contact me. Consultation link is in the bio. And I'm going to let you know once the other person will have a bond hearing coming up. Once the other persons get released, I'm going to come back to explain to you, and you might probably like the news as well. Okay, we're here to help Thank you very much. Until next time, bye-bye.